back to the justices.
Back to the justices.
Opo, but is it correct to say, though, Judge, that the four friends of court had a very liberal interpretation of this particular issue?
They were very objective. They were very objective.
Okay, but you're saying that they threw back to the justices if the justices should have a liberal interpretation of this issue at hand.
Particularly because most of them agreed that the facts on the case, especially the birth-to-only documents, the birth certificate and the marriage contract, were disputed, and not even one of them would admit or stipulate on the matter.
Okay, so going back to what you are asserting or injecting, the Convention on the Rights of the Child, you're saying that any child who is born of a mother or a father Filipino, whether in the Philippines or out of the country po, or kailangan only in the Philippines?
We follow under settled jurisprudence and in the Constitution the jus sanguinis, meaning therefore that a child born of a Filipino mother or Filipino father is a natural-born Filipino.
Okay.
citizen.
Just as long as you have one parent that is Filipino, you automatically become Filipino.
Basically with certain qualifications.
Ano po yung qualifications?
For example, the rulings cited by petitioners mention about the legitimacy of the child. Now, during the argument, Father Berna said that this case is unprecedented because there is the cases that they are citing, the factual milieu, do not apply in this case because there is none in Philippine jurisprudence that will duplicate this case.
So, in simple terms, you cannot cite jurisprudence because no such incident ever happened in the past. This is a new, one of a kind. Or
A
the
case
first
of first
one.
impression in judicial and political history.
Opo. Well, that's important, judicial history. So, di ba, when, kasi how we understand law, Judge, no, para mas maintindihan po natin ang mabuti, nagkakaroon po kasi when cases are actually decided upon, judges or justices look at past cases on the kind of decisions were made on a particular issue. What you're saying right now is that this issue of FPJ is one of a kind. This is the first, if ever. So, they cannot cite jurisprudence po dahil wala pong kaso na maikukumpara dun sa kaso ni FPJ ngayon. Dahil wala pa hong ganitong klaseng kasong nangyari in the past po.
Yes, specifically for the amici curiae, and especially Father Berna stressed that all the cases cited by petitioners and even respondents are obiter dicta rulings, meaning opinions in the decisions of all Supreme Court cases since 1900 until 2003 and today that are opinions only of the court and they do not form part of the main decision or the law of the land, the jurisprudence. So what forms to be, what will be called stare decisis, meaning binding precedent under our law, are only decisions which squarely raise the issues regarding the facts raised. So,
nakakalito na po, Judge. So, meaning to say, in simple terms po,
the cases cited are not binding precedents. They do not bind the Supreme Court because they are mere opinions in cases.
So, sa madaling sabi, hindi natin pwede gamitin itong mga kasong na-desisyonan ng justices noong nakaraan dahil hindi po ito parang conclusive. Hindi siya binding. Hindi natin to pwede gamitin dahil opinion lang to ng mga huwes.
Opinions in the decisions called obiter dicta, meaning not binding precedents.
Okay.
That is the technical...
No binding precedents. So, walang nangyari nung nakaraan na pwede natin gamiting basehan para bigyan ng desisyon itong kay FPJ?
None. No case.
Mr. Valdez called in and asked, would the guest please clarify the Treaty on the Rights of Children were ratified by the Senate in 1990? If this is the case, the treaty does not have the impact of a law yet. And what does rights to nationality entail? What nationality does the child take under this treaty? Can the child choose his nationality later on in his life? Thank you so much to the caller.
as I stated, this treaty is now part of the law of the land because it was adopted by the UN Assembly in 1989. It entered into force on September 2, 1990, and the Philippines became the 31st state to ratify this CRC treaty on July 1990 by a Senate Resolution 109, and by virtue of the Constitution, Section 21 of Article 7, this is the force and effect of law, meaning part of the law of the land, like the Civil Code, Family Code, on par with it.
So, pagka-treaty po at ni-ratify ng Senado, does it take years before it actually becomes law, or once the Senate ratifies it, it's law?
Upon publication of the Senate resolution,
That is
15
law.
days.
All right. Balik natin yung question nung ating caller, because there were a number of questions that need to be answered. Yung una niya is the Treaty on the Rights of Children ratified by the Senate in 1990. If this is the case, the treaty does not have the impact of a law yet. I wonder why. Bakit po sinasabi yan that the treaty does not have an impact of a law yet?
The treaty, if not ratified by the Senate, does not have any force and effect.
Yun
of
na
a
nga
law.
po, but you said it was ratified in 1990.
Yes,
All
so
right,
it is-
so it has the effect of a law.
Not only the effect, it becomes part of the law of the land according to the
Okay, so it becomes
jurisprudence.
law. All right. What does rights, or what rights do the nationality actually entail? Ano pong sagot doon?
The CRC specifically and absolutely affords complete and comprehensive rights for the children. Under this treaty, children, Filipinos or foreign, are granted absolute protection rights, like rights to nationality.
Opo, I understand
Filipino
that.
citizenship, natural-born Filipino.
But what does it take for a child, sabi mo, under the CRC, parang my understanding, Judge, is you're saying that under this law, this treaty that has the effect of a law, or is actually a law, the Convention of the Rights of the Child, grants protection to children, the right to nationality. So does that necessarily mean that at a certain age, kailangan ho sila pumili kung ano ang kanilang magiging nationality? Let's say they're coming from one Filipino and one foreign parent.
Well, no, there is no qualification. At the moment of birth, once a child is born, by virtue of his birth, whether he is a Filipino or a foreigner, as a child, even if he is now at the age of 40, since he was a child when he was born in 1939 or 1940, he is granted this absolute comprehensive rights called protection rights, like rights to nationality. And this is a political right because nationality includes citizenship specifically.
Opo.
Because there are children who were born before this treaty. The problem is they have no citizenships. They are stateless. So now, under our laws, there is such a thing called dual citizenship, voluntary.
Opo.
That was
Pero
discussed
bago lang
further.
yan hindi ba ho, Judge? Bago lang itong
Yes,
dual
but
citizenship.
irrespective of dual citizenship, the treaty remedied the situation of stateless children. This is the case of Poe.
Opo. I'm trying kasi to understand you further, Judge, dito sa CRC. So under this treaty, children, Filipinos or foreign, are granted protection rights like the right to nationality. So an example would be if you were born, ang tanong ko po kasi ito must you be born in, let's say, the Philippines, to be able to be a Filipino citizen if you have one Filipino parent and another foreign parent? Kasi I find this vague. To be honest, I don't know where you're still going with this particular treaty. Some rights are protected. Rights of children are
Yes,
protected.
rights are protected.
But when does it necessarily mean, sir, na judge na kayo ay Pilipino o kayo ay hindi considered na Pilipino? Kasi meron ka pa rin namang karapatan. Pero where do you delineate na ito Pilipino, ito hindi? O kailangan dumating sa particular age po, judge, na pipili sila kung anong nationality po sila?
Precisely, that was the problem of the amici curiae. Most of them are threw back the question to the court because the two documents presented and not even admitted, stipulated, they refused to, are the birth certificate and the marriage contract.
Opo.
So the problem is there must be